everybody, I'm Seth Weissman. I'm General Counsel to the Georgia Association of Realtors, and welcome to another episode of Legal Lines. Today we are going to look at the question of what is the broker's liability if they were supposed to get the earnest money, it never showed up, but the broker forgets to tell the seller that in fact the earnest money did not arrive. And what typically happens in that situation is the buyer who doesn't write a check for the earnest money also eventually breaches the contract. The seller then makes a demand for the earnest money, and the broker is in the unenviable position of having to say to the seller, "Gosh, I forgot to tell you, but the earnest money never arrived from the buyer." And what sellers then typically do in that situation is the seller then says to the broker, "You were supposed to have collected it, you didn't. I want you to write me a check for the earnest money." And does the broker have to write that check? Well, certainly they can write that check if they so choose. And sometimes brokers feel that they messed up. They would rather write a check to create goodwill, and they move on down the road. But legally, I am not sure that the broker has liability for that mistake. Clearly, they should have collected it if they could have. Clearly, they should have notified the seller. But if you really think hard about this situation, let's say they had timely notified the seller, "Gosh, the earnest money hasn't arrived." That would not magically result in the earnest money being deposited. The only thing that would result in is the seller would have known a week or two sooner that the buyer's earnest money wasn't there, and maybe it could have resulted in the contract being terminated a little more quickly. But my experience is if the buyer does not show up with the earnest money, notifying the seller that you haven't received it does not always then mean that the buyer's going to write a check. More often than not, what it simply means is that the seller learns sooner that the buyer is going to be in default. So what I would actually say as the holder of the earnest money is, "I'm sorry I did not notify you sooner, but even had I notified you sooner, it would have been no guarantee that the buyer would have written the check. And if you wish to pursue the buyer for the earnest money, you as the seller are free to sue the buyer to try to collect the earnest money." So the answer with regards to liability is it's not a mistake you want to make, but I also don't think that it automatically means that the holder of the earnest money has to write a check because the earnest money has not arrived. I hope this episode of Legal Lines has been beneficial. As always, it's great to see you, and please continue to tune in. Bye now.